Shalom, this is Yah is Magnified, and I'm back with another informative video. Today's video is titled, How Would You Respond? But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth. Nothing more, nothing less. So with that being said, guys, I need you all to hit that like button. And also, if you're new to my channel, hit that subscribe button. And also hit that notification bell so you all can be notified as I'm dropping these powerful videos. So without further ado, let's get to it. In today's video, we will in fact be discussing the state of Virginia, okay? For all those who have been following me for quite some time, you all know that Virginia was in fact the state that I was fighting and the state that I received remedy in, okay? And I must state, guys, that Virginia is hands down the hardest state to win in child support, okay? And the reason being is the mechanisms that they have set up in order to prevent you from proceeding forward to a higher court, okay? So in my situation, as you all know, that when I was fighting child support, I didn't have a court order support. I had an administrative order of support, meaning that I went down to the agency. We had a conference, and I actually signed the documents. Okay, once I signed the documents, there was no arrears placed on the documents. Okay, and because there was no arrears placed on the document, you know, if I didn't agree with that, I can simply petition the juvenile domestic relations court and schedule a hearing. So that's what I did, guys. After I signed the order, I realized that I didn't agree with it, so I then petitioned the district court, the juvenile domestic relations court, in order to have a hearing, right? And after I had the hearing, the juvenile domestic relations court just simply kept everything the same back then, okay? So now, my aunt, who's in Virginia, I'm going to show you guys how crazy Virginia is, because in Virginia, if you have any arrears, then before you can appeal, you must pay an appeals bond. So to further prove that, let's go. Okay, so now, as you all can see, we are in fact coming from the Code of Virginia. We're going to pick this up at the very top where it states subsection 16.1-107, and it reads, requirements for appeal. And it reads, no appeal shall be allowed unless and until the party applying for the same or someone for him shall give bond in an amount and with sufficient surety approved by the judge or by his clerk, if there is one, or in the amount sufficient to satisfy the judgment of the court in which it was rendered. So again, guys, right here where it states, hold on, let me highlight it. I'm not trying to highlight it. Okay, let me highlight it where it states right here, guys. Okay, it states, in an amount sufficient to satisfy the judgment of the court in which it is rendered. So now, if the judge claimed that you owe $10,000 in back arrears, you must pay that $10,000 first on an appeals bond before you can even file your appeal. Okay? So in my aunt case, he had to pay almost $6,000 in back arrears in order to do an appeal. Okay? But let's continue. Then it states, let's pick it up where it states either, right here, so you can see. It states either such amount should be included the award of attorney fees, if any. Such bond shall be posted within 30 days from the date of judgment, except for an appeal from a judgment of a general district court on an unlawful detainer pursuant to subsection 8.01-129. So again, guys, this what makes it extremely hard in Virginia, okay? Because if they don't like what you're saying, they can simply draft up an extremely high amount of arrears that will prevent you all from going to a higher court. This is why I say Virginia is hands down one of the hardest states to win and support, okay? So now let's go back to the order. Let's go back. So now let's go over the order. As you all can see, it states what? In the Circuit Court of the 31st Judicial Circuit, all right? The reason why it says the 31st Judicial Circuit in the Circuit Court is because my aunt, he filed his appeal from the Juvenile Domestic Relations Court, right? Which he had to pay an appeals bond almost in the amount of $6,000. It was like $5,700 and something dollars that he had to pay just to get the appeals, okay? So we're going to go over this order and we're going to see how slick they think they are. But I want to know, after we read the order, what would you guys do if you was to receive an order like this, okay? So now, again, let's read it. It states in the circuit court for the 31st Judicial Circuit, right? Then it states Division of Child Support ex rel. Okay, his child's mom name I crossed out. They was the petitioner. And they was up against my Ak, who was the respondent, right? And I crossed his name out and the case number. And it reads, order. This matter came before the court on March the 21st, 2023 on respondent's appeal of a support order from the Prince William County Juvenile and Domestic Relations Court. What I was just telling you guys, prior to reading that. But let's continue. It appearing that petitioner blank and respondent blank appeared, and it further appearing that the respondent failed to file the notice of appeal within 10 days from the entry of the final judgment of the Prince William County Juvenile and Domestic Relations Court. It is therefore adjudged, ordered, and decreed that this matter is removed from the docket for lack of jurisdiction pursuant to VA Code subsection 16.1-296A. This matter is ended, with the judge's signature, court stamp, and everything else on it, guys. So my question to you all is, if you was to receive this document, right, or this order, what would you do? Okay? Leave it in the comments, guys. But I'm going to let you all know what we have done, okay? So in this case, we simply filed a written objection, all right? And the reason why I'm going over this, because another one of my AUKs hit me up in my email, I mean, not my email, but on my last video, and asked me, can I show him or show people how to write up the documents? And I simply told him I cannot show you guys how to write the documents, but I will give you all, certain points to look out for and how to actually prepare or get your thoughts process rolling to support your documents that you're going to write in response to orders or whatever documents that you receive, okay? So this will be a slight example. So now, in this case, we would simply file a written objection, okay? Objecting to this order. And after we object to the order, we will also file a new notice of appeal to go where, guys? To the Court of Appeals, okay? Why? Because we're challenging this order, all right? So again, this is not legal advice. I do not give legal advice, guys. I'm just simply telling you all the truth, okay, on what's the next step to be done, all right? And it reads, again, so let's read the order one more time, because it states, this matter came before the court on March the 21st, 2023, on respondent's appeal of a support order from the Prince William County Juvenile and Domestic Relations Court, right? So we know that has taken place. He did file an appeal from the order coming from the Juvenile Domestic Relations Court. So that is a fact, right? So the next one is what? It appearing that the petitioner, who is the Child Support Enforcement Agency and his child's mom, and the respondent, who was my AUK, appeared. That could also be a fact. You don't have to really argue that. But now let's go to the next one. The next one is what? It further appearing that the respondent failed to file the notice of appeal within 10 days from the entry of the final judgment of the Prince William County Juvenile and Domestic Relations Court, right? So the court is stating that it appears, or appearing. He didn't say that it was. He said it's appearing, right? But the word appearing in law simply means facts. To further prove that, let's go to the Black Law Dictionary for the word appear. So now you all can see we're coming from the Black Law Dictionary. Let's scroll down to appear. Highlighted area, guys, and it reads, in practice, to be properly before a court, as a fact or matter of which it can take notice, to be in evidence, to be proved, making it appear and proving are the same thing, okay? So to make it appear and proving are the same thing. So basically when the court's saying it's appearing that he did not file his notice of appeal within the 10 days, you see, that was for a reason, because the court is trying to make it seem as though it is a fact, all right? And if by them saying it's a fact, they're trying to say that because he didn't file it within the time permitted, then he don't have a right to an appeal, and they're going to try to simply keep his appeals bond that he paid, which is wrong, guys. You know why? Because we, in fact, filed everything in its proper time. But now let's go back to the order. Let's go right back to the order, guys. So we're right back at the order. Let's pick this up again where it states right here, guys. It is further appearing, right, that respondent failed to file the notice of appeal within 10 days from the entry of the final judgment of the Prince William County Juvenile Domestic Relations Court. So that would be a point that you would challenge, guys. And how would you challenge that? You would challenge that in your written objection. By what? by simply explaining the timeline on everything that has taken place. So let's say the final judgment was entered on March the 18th, right? So if he filed his notice of appeal on March the 21st, it's obvious that he was in the time to file the notice of appeal, right? Cool, okay? So once that has taken place, then you will put that down in your appeals, your written objection. So when you do go to the appeals court, the appeals court know that you objected to the lower court order, and on the grounds that you objected to the lower court's order, and then when you go to the appeals court and you will file your appeals brief, you will keep your argument on the point that what? That you did file your order, and you did file your notice of appeal and appeals bond in the time allowed with the codes and stuff that I just read to support that argument, guys. And that's how you respond back to these documents, okay? So that's what I'm going to do for today. If you need my help, hit me up in my email at yahismagnified@gmail.com. Let's get this right wisdom, this right knowledge, and this right understanding. Cop that merch. And with that being said, shalom.